class on the 2020 GAR, G-A-R, Georgia Association of Realtors. Do y'all say GAR or G-A-R?
GAR.
GAR. That's what I say too, but some people say G-A-R, so I just say all three.
Maybe you just learned it from you guys.
This is the class on the changes that GAR made to the contract package in 2020. This is not a Contracts 101 class. We're not going through the contract. This class is just specifically to go over the changes that were made for the 2020 forms, okay? Now, in addition to that, GAR also changed the contracts every January. Actually, they do it in December, of course, right? But they're available for us as agents every January. They also do a mid-year review, sometime around, usually it's around May. Last year they did it around June. Typically, agents take a contracts class at the beginning of the year, and then they don't take another one until the beginning of next year. So you never get formalized training on those mid-year changes because you don't want to waste 3 hours without getting CE, right? So usually GAR, the intention of GAR for those mid-year changes is typically typographical errors, sequencing errors, punctuation, grammar, things like that. But every now and then they throw in a couple of doozies. So not only are we going to cover the changes that they made for 2020, we're also going to cover the changes they made June 1st of last year. And there are a couple of doozies. So, everybody in the right place? Mm-hmm. Now, we do have a contracts class. The school, Georgia Real Estate Academy, does have another class approved through GREC for an additional 3 hours of CE called the 2020 GAR Contract Dissection. We're going to teach that later on in the year. That is a full contracts class going through everything. This one just on the changes. All right. So my name is Dana Sparks. Welcome, everybody. We do have a full class today. It was overbooked, so I don't know if I should say this out loud, but I'm kind of glad some people didn't show up because we are still full. I am the director of the Georgia Real Estate Academy, which is the entity offering this course for CE. I see a lot of familiar faces, but I see some new faces too, so welcome. We do have agents from all brokerages because the philosophy of the school is that training and education is the foundation of success for any profession, especially in our profession, especially with things that change all the time. I'm also the managing broker of Maximum One Realty, which is the brokerage that's hosting us. The only reason I tell you that is because this is a contracts class. So there are some examples that I'm going to point out regarding how these apply to actual day-to-day contracts. Now, I don't see every contract. We have 2 compliance brokers that see every single contract. I just see the contracts when they get in trouble. So I see like 1, 2 a year, right? Just kidding. We are so fortunate and so excited to also have Andy Hartman, the Hartman Law Firm, to give a legal perspective on the contracts and the changes and point out some things. And Andy, thank you so much for being here. I'm really excited because there is a broker perspective on what you guys do as an agent, and there is a legal perspective. And we hope that they overlap, and they do overlap in the majority of instances, but there are some circumstances when they're different. For example, you're trending a contract, your compliance broker will go back to you and say, you need this, 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 and this. And you'll put that hand on that hip, shake that hip, and go say, Andy's an attorney. I'm going to show him and get his opinion. And Andy will say, well, no, this is a completely enforceable contract between the buyer and the seller. But I defer to your compliance broker, right? The reason is your attorneys are, depending on how you ask the question, your attorneys are looking at contracts for enforceability, validity, non-voidability between the buyer and the seller, right? Do a buyer and a seller need us as agents to convey property to one another? No, I mean they do, but not really. So when you ask an attorney to look at a contract, if your compliance broker said there's an issue, the attorney can say, no, it's perfectly fine, because their perspective is title, unencumbered title being conveyed, so forth and so on, good and marketable title, right? Your compliance brokers, guess who we're looking out for? You guys, we love y'all. We want to keep you out of real estate jail. So we are also looking at your contracts for an additional overlay of compliance with license law. So that's why I'm really excited to have a broker perspective as well as a legal perspective on the contracts. So thank you, Andy. I'm going to let you introduce yourself.
Well, thank you. Yes, I'm Andy Hartman with Hartman Law. We have 5 locations around the North Metro area. And to expand on what Dana said, there are some nuances between a closing attorney and a real estate attorney as well. And I think some of you, especially if you've been in the business long enough, you can quickly tell the difference between those two. And you know, sometimes even within my own firm, I'll be quite frank, you know, we hire, I have real estate attorneys, and then I have contract attorneys who, you know, they're great at the closing table, but you know, their personalities lend themselves well to getting your deal done. But when it comes time for the deep dive into the contract, you know, they may not really have been maybe trained or have kind of that breadth of just kind of day-to-day grind and experience to really have to deep dive into some of these issues, because they've really, throughout the time in their career, they've been sort of groomed at the closing table. They've always been at the closing table. They've never been in the back room doing the getting your fingernails dirty kind of work. And the other thing is, when it comes to contracts, the most painful thing that can be done to me is just for someone to come to me and say, Andy, I just need you to draw me a simple contract. Because you know, that is one of those things that is, lawyers are hired pessimists, okay? We really are. So if you come to me and say, I don't want it to be more than 3 pages, and I come to you and I'm like, oh my gosh, but if I leave this out, this could happen. So I put that in, and you're like, I don't want that, that's going to scare them. It's like, but that protects you. And you know, so that's how we end up with a GAR. And then a sentence goes in, and next year that sentence comes out. 3 words go in, and it sends everybody into panic. And that's why we end up with this class every year. So with that being said, I say we just start our deep dive, and let's get into it.
All right. Before we get started, obviously y'all can see computers are the greatest things that slice bread until they update, right? So we have started this update over an hour ago, and we are still updating. I also am going to make sure everybody has handouts in a second, but before we need a CE class just comparing some of these home warranty programs, don't we? You guys, everyone has their own unique features and benefits. As a broker, I don't care who holds your license, you guys give out more than one name and make sure that you can demonstrate it is your client or customer's choice of which home warranty program they pick, which inspector they pick, so forth and so on. I've got horror stories that I'm not going to share, but just be, you know, you've heard that from pre-license school, but be able to demonstrate that. All right, do we have anybody who has been licensed less than a year? Okay, fewer than 3 years. Oh, okay, over 5 years. Okay, over 20 years. Over 30 years. 40. 45. Hey, sold. How long?
I can't remember.
Okay. How long?
27, I think.
27.
Since 85.
Since 85.
84.
85.
84.
84. So are y'all's license numbers like 2-digit numbers? No, I'm just kidding. Just kidding. Start with a 1. Okay, just want to let you guys know we are going to teach and gear our remarks at a more elevated level, and if you have been licensed less than that, Andy and I'll be more than happy to answer questions at the break or after class. And there are, I will tell you, as a broker, even the most experienced agents, there are a lot of questions and issues that we have on some things that some other of you may consider basic. But it's not basic if you've never had to deal with that before, or if it's something new that GAR has come up with, like the attorneys holding earnest money. There's a whole lot of issues. So, ready to get started?
Yep.
Our computer is almost updated. Before we get started,
And if I may interject
Sure.
one thing, I want to welcome by live feed our folks in the Maximum One Emerson office.
hello
We
Emerson.
have folks there too, and I'm trying to figure out how do we communicate with them, Holly, because I don't want to stand in the wrong place. Do you have somebody telling us where I'm not supposed to stand so they can see?
Yeah.
So you can see. and
Can you
can
answer
say,
questions?
Will you, and yeah, do you have the means of getting questions from them if they have questions? Okay. Okay. All right, and so you can tell me if I need to get out of the way, if I'm moving around
And I move around.
Okay.
All right, you should all have two handouts. One says 2020 GAR contract changes, hosted by instructors Andy Hartman and Dana Sparks. The other one says GAR Contract Forms for CE class. Who's missing which? Who's missing the first one?
I only saw one put up there.
Who's missing the first one? Okay.
You got
I
those?
need the one with the max. Yeah.
Anybody else? All right, who's missing the handout that just says forms?
Dana, I did need that one.
Okay.
Sorry.
All right, we welcome questions and comments, but please know, okay, I've got good news and bad news. Good news first. The good news is there are not a whole lot of changes. The bad news is Andy and I can talk for more than 3 hours on the changes they made. So we will be here for the full 3 hours. Okay, GAR. Forms. First one. Forms. Anybody else? All right. All right. The way this works is the smaller handout, the one that has Andy's and my name on it. This is the PowerPoint that we will show in 9% of an update. So hopefully it'll come on soon. But regardless, you guys have the actual slides. The other handout are the actual GAR forms for 2020 with the changes actually underlined in check marks. Okay, so you guys can see. So you're gonna kind of do a balancing act between the two forms. It will be much easier once we actually have the PowerPoint up here. Before we deep dive, just a couple of things. As I said, GAR makes changes mid-year every year and then releases a new copyrighted licensed document every January. You access those through our docs, through FMLS, which is now changing to Remind Docs. They've done a soft launch as of the 4th. Y'all learn how to use those because RDocs is going to go away. And you guys who have been licensed for, y'all know FMLS goes through 20 gazillion changes and it causes mass chaos until you learn it. Just when you get it under your belt, they change again. So, or through Georgia MLS through Transaction Desk. That's where you can access the forms. Now, wherever you guys go to access your forms, to get your purchase and sale agreements, your exhibits, your amendments, so forth and so on, there is also a table of contents of what's in the forms packages. There's a whole packet of every special stipulation they have, and they have the changes. So in the smaller packet, I have printed the 2019 revisions that they made June 1st, as well as the 2020 changes. So you guys have an index of all the changes. We're not going to cover every single change. We're just going to cover the primary changes that you guys are going to deal with day to day. I encourage you all every June of every year, go back and look for the revisions that they make and scan down and see what forms were changed so you guys can see, because what happens inevitably, I get the call, what's this? What's going on? I saw this. And what happened is GAR changed it, and you're not aware of the change or how to address that with your clients until you're in the middle of trying to write a contract, and y'all are calling me at 10 o'clock at night. So, just saying. So I just want to let you know that's in here, and that's available to you wherever you access your forms packages. All right? All right, we're at 100%, but you know, it's got to, like Andy said, it's got to restart a couple of times. So, the PowerPoint is in this package. The forms are in this package. There's other things in the slideshow that we're going to skip regarding how you access the GAR forms. If you're a member of a board, you have them at no additional cost by virtue of your membership to GAR. If not, you can pay GAR for the use the forms. Once the new ones are out, it's a GAR licensing violation to use the previous version's forms. Like, you can't use the 2019 forms now that the 2020s are out. But that doesn't mean if you have a listing agreement signed in December, and it doesn't mean you need to go and get a new one signed. It's just moving forward, any new forms that need to be signed need to be on the 2020 forms. And I'm telling y'all, it is crazy. I guess some people download the forms into their computer as a PDF form. We had a termination and release that was on a 2015 form, and it favored their client more. And so anyway, that is a GAR licensing violation. Regardless if you have paid for it or not, GAR can take away your right to use their forms and can take away your broker's right to use their forms. So those are just a couple of the first slides that are in there, but I think we should just dive in. All right, again, we welcome your questions. If we limit you, we're not being rude. We just want to make sure to get everything covered. All right,
Okay.
You want to start?
Sure, yeah, I'd say the first substantive thing to look at would be in the purchase and sale agreement. The first change that's made is to the warranty of seller section in your purchase and sale agreement, which if you're one of these uber form nerds that knows it by form number, which I'm definitely not, the F201 purchase and sale agreement, in the purchase and sale warranty of seller section, the only change they made.
I'm going to interrupt you. So
Okay.
I'm going to just reference the handout that's the contracts, and you'll see I have little handwritten numbers at the bottom. So in this handout that says the contract forms, it's on page 2, which is nice because it also corresponds to page 2 of the purchase and sale. So Andy is on this paragraph B1 where purchase and sale.
And if you were preferring to follow as if it were a slide, and if it were already up here, we would be looking at this one, okay? So in the section warranty of seller, it's always been a matter of taking title under the limited warranty deed, that the buyer had to take title subject to any drainage easements, general utilities, sewer easements. That's always just sort of common sense. When you're going to be a buyer and you're going to take title to the property, if there are existing utility or sewer easements, which obviously are going to most likely benefit the property you're buying as well, but they may benefit neighboring properties, and they're going to burden the subject property a bit. Well, every once in a while, you're going to have a buyer that wants to get out of the contract for some other reason, and they're going to be a little bit savvy or sneaky, or they may find a lawyer that's a little savvy or sneaky and say, hey, none of the actual livable improvements encroach over the utility easements, but the driveway or sidewalk does, so I'm going to use that as a reason to get out of this contract. Well, finally GAR has closed that loophole by saying, hey buyer, we don't care if the driveway is paved over a utility easement or a sidewalk is. You're gonna take the property subject to that, because let's face it, if a water line bursts, what do the utility companies come and do? They come and they jackhammer the driveway up, they fix the water line, they repave the driveway, everybody moves on. It's not a big deal. So that loophole was closed by adding this one sentence: buyers can't get out of contract simply because the driveway is paved over a water line. That's a common thing in all subdivisions and everywhere else. Okay, so that's the first substantive change they made to that contract.
Awesome. All right. The next change, all right. The next change is under the Brokerage Relationship section, which is page 4 of the handout, and it's in the disclaimer section. And before I get to the change that they made for 2020, this disclaimer paragraph, this is what Andy was referencing when agents come to him and say, hey, Andy, write me up a quick contract, please. Well, if he doesn't include this kind of verbiage, it potentially puts you at risk. And a lot of agents, when you guys are going over contracts with your clients, we're almost there. When you're going over contracts with your clients, you hate reading this disclaimer section. This disclaimer section, do y'all remember Hogan's Heroes? Remember Sergeant Schultz? What did he always say?
I see nothing.
I know nothing, I see nothing, right? This is your Sergeant Schultz paragraph. And a lot of times it's a little bit difficult to present it to a client because you've got the balance of, I don't know anything, I'm merely a lowly real estate agent filling in the blanks on a purchase and sale agreement that's been prepared by an attorney, versus you're paying me a lot of commission to fill in the blanks. But I'm telling you, and if you've been in my classes before, you have heard me say, nothing is an issue until it's an issue. But when it's an issue, this paragraph will protect you should it become an issue. Hopefully it never becomes an issue. And basically, I'm just going to read what this paragraph says. It says, buyer and seller have not relied upon any advice or representations of the brokers other than what is included in this agreement. Brokers shall have no duty to inspect the brokers, and in GAR, in the contract, it has it further else in there. When it uses the term brokers, it also means you by extension as an affiliated licensee, because you're affiliated with whom? Your broker. All contracts are written in the name of whom? The broker. Your broker, right? So they use the terms interchangeably, and it is defined further in the contract. But brokers shall have no duty to inspect the property or to advise buyer or seller on any matter relating to the property which could have been revealed through a survey, appraisal, title search, official Georgia wood infestation report, utility bill review, septic, blah, 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 blah. In other words, buyer, if there is something that is of concern to you or important to you, you need to take the steps to have it checked out by an expert in that area. It's not just the agent. You can't rely on the agent of what they're saying. Then it goes on to say, buyer and seller should seek independent expert advice regarding any matter of concern to them relative to the property in this agreement. Buyer and seller acknowledge that brokers shall not be responsible to supervise, monitor, supervise, or inspect any construction or repairs to property, and such tasks clearly fall outside of the scope of real estate brokerage services. Okay, if the broker has written any special stipulations, this was new a few years ago, herein the party for whom the special stipulations were written, A, confirms that each such stip reflects the party's complete understanding as to the substance and form. B, hereby adopts each special stipulation as the original work of the party. That's GAR saying you can't sue us on a special stip that your agent wrote. That's not coming from GAR. That's GAR's covering their tushy. And C, hereby agrees to indemnify and hold broker who prepared the special stipulation harmless from any and all claims, causes of action, suits, and damages arising out of the special stip. I'm going to read the next part, then I'm going to let Andy comment a little bit more on special steps. Now, here's what they've added for 2020. Buyer acknowledges that when and if the broker answers a question of the buyer or otherwise describes some aspect of the property or the transaction, broker is doing so based upon the information provided by whom? Seller. The seller, rather than independent knowledge of the broker, unless the broker says this is from my independent knowledge. You guys have got to be careful when your agent-to-agent email, when it has to do with something especially materially related to the property. there are forms that y'all should use that has the buyer and seller signatures. And I'll find that in the slideshow because we've got that up and running, and I'll let Andy talk a little bit about this from a legal perspective.
This is extraordinarily important. I'm not sure if there's anybody here from the brokerage in which this happened this summer, but I had a closing this summer, and both the buyer and the seller and both of the agents were Hispanic and spoke very little English, but there was translation that could occur. And it was, who knew what at what time was the subject of some debate, but it was put in the FMLS that it said something to the effect of fixer upper special or something like that. So it was definitely a property that needed some work. It was also put as a special stipulation, buyer to check with city for sewer tap availability. So that was a special stipulation, and you can decide if that was the proper place to put that. So what ends up happening is they find out, the buyer finds out 3 days before closing that the property needs to be approved by the city whether or not it can have a sewer tap. Well, what happens is the city says it's an uninhabitable property unless there's $60,000 worth of work done. And my attorney advised the buyer of this at closing in English, and then it was translated to the buyer. So my attorney doesn't really know what was translated, but it was translated by the buyer's broker, by the listing agent to the buyer. The listing agent said that she told the buyer that it just needed $60,000 worth of work, and then the home could be lived in. And she said the seller is who told her that. Well, it turns out that home, what the seller really knew was that the home could never be lived in. Oh. It was a condemned home. Oh, wow. But the listing agent got that information from the seller, and that's what the listing agent is going to court with. So, I mean, she's, now that was a 2019 contract. But, that was a caveat emptor, buyer beware thing. All that buyer had to do was go directly, even with the rest of that paragraph. Forget that last line being in there. All that buyer needed to do, or the buyer's agent, quite frankly, would do their due diligence and go to the county themselves, and the county would have told them that's a condemned property. And the second example of that was I sat in the closing. Is there anybody here from Path and Post? Well, Brad Nix, who's one of the principals and brokers at Path and Post, I happen to think of him as one of the smartest and stand-up guys there is. And I was sitting at the table with him last year, and the father of the buyer asks him, he said, what's that property next to this property zoned? Are they ever going to build a school or a church there? I don't want a bunch of people behind the house. And Brad's like, I have no idea what that property zoned. And this guy literally says,
bleep.
what did we pay you for? And starts just reading him the riot act, and Brad's like, just reading him up and down the road, and Brad's standing up for himself. And, that's another one of those situations where you gotta really protect yourself as a broker, and make sure your buyers know that you're not held to information that you're not hired to advise them. So, and these are the paragraphs that protect you from that. So.
And that's another reason, if you guys are, so this is where the broker legal question comes in. If you guys are ever a party to a contract that is not a GAR contract or an RE Forms contract, this disclaimer paragraph may not be in there. And so this is why a lot of your brokers will, this is one of the issues where your brokers are saying, y'all use GAR or RE to protect yourself in these certain situations. There's example after example after example of these issues. And like I said, it's not an issue until it's an issue. But when it's an issue, it's expensive. And the other thing is, even when you're right, if you have to hire an attorney or invoke your E&O attorney to defend being right, it still costs you money. It might not cost you as much money as if you lose a case, but it still costs money to be right. So basically, a lot of these paragraphs lay the legal foundation for your attorney to make an argument to a judge who is then going to look at all the circumstances. But don't get in that situation. So there's a couple of other things that are in the slideshow and in your handouts. Remember your question. To help you with this, one of the things is, and we don't have samples of this in your actual form, but GAR has a form called F325. It's called Broker's Information Disclosure. And again, it is in your other handout with the slides, and I don't have the slides numbered, but this is a great form to use. It's a question and answer form. It says question, fill in the blank, answer, fill in the blank, source, fill in the blank. So again, you guys are too nice, and I hate saying that, but those of you that have been practicing for a while, have circumstances in community and society changed a little bit? Sometimes it has. So if you use this form, then you have documentation of their question. For example, if the buyer says, what's the zoning of this? As the agent, you can write out the question, write out the answer, and put in the source of that information. And it does have hold harmless language on there. So again, some of these things are preventative, and you might think, gosh, we have enough paperwork already. But the more paperwork and documentation that you can demonstrate to an authority, i.e. a judge, an arbitrator, so forth, the GREC, so forth and so on, that you can say, look, I did my best to provide that information with the source of the information. And all of that does balance out to Georgia being a caveat emptor state. What does caveat emptor mean?
Buyer beware.
Buyer beware. And we are a state of caveat emptor for any purchase you make, real property or personal property. Basically, if I can summarize, the buyer needs to make themselves 100% satisfied with what they are purchasing before they exchange money for goods or services.
There's one exception to that, or, there's one notable exception to that, and that is a latent or hidden defect that the seller knows about that the buyer cannot reasonably make themselves aware of without, a significant destruction of the property.
But proving seller had knowledge of it is that's the tricky part in those cases. And we're having a lot of those issues right now, but we'll get to that a little bit later when we talk about the seller's property disclosure form. But anyway, agent to agent email, you guys be really, really careful. And another example, like Andy brought up, is the interpretation of that. So, all right. Next section. Default. Now the remedies of the seller and the buyer for default, those got changed in August of 2018. That was another, it wasn't even their mid-year review. They did in 2018, they did two reviews, one in May and then one in August. The August one changed for the default section based on a lawsuit that was here. But for 2020, they changed the rights of the broker for default. Andy, you want to talk a little bit about that one?
Well, for survivability of my practice reasons, I tend to, I try to shy away from getting into the middle of too much default resolution stuff between agents because I like to love all agents. But when it comes down to the agreements, you had situations that if there was a commission agreement, that agreement controlled. You had situations where you had one party that didn't have a relationship with the defaulting party, and so you were missing documentation, and you didn't have sort of a nexus between the person that defaulted and you had a person that defaulted who didn't actually have a written transactional relationship with the person that is owed a commission. Well, now they kind of stripped that away and said, if you defaulted, you owe a commission regardless of whether or not there's paperwork to back that up.
So the verbiage in 2019 basically said, in the event this agreement is terminated or fails to close due to the default of a party hereto, the defaulting party shall pay as liquidated damages to every broker involved in this transaction with whom the defaulting party does not have a brokerage engagement agreement, an amount equal to the commission. What's a brokerage engagement agreement on the seller side? What is it on the buyer side? Buyer brokerage. So basically, the way it was worded last year is in the purchase and sale, if a party defaulted, like let's say it's a buyer that defaulted, then this verbiage was for the listing broker remedy. The buyer broker remedy deferred back to the buyer's brokerage agreement. So like Andy said, they've changed it this year that basically the verbiage is if a party defaults on the purchase and sale, because they didn't necessarily default on the buyer brokerage if they're still working with you. If a party defaults on the purchase and sale, both brokers involved now have potential remedy to pursue their commission they would have earned had either party not defaulted. So it still incorporates other documents that reference commission. So what are the other documents that would reference commission? Instructions of closing attorney, buyer brokerage, and listing brokerage. So the buyer brokerage and the listing brokerage are still incorporated in here, but basically the intent, my understanding of the intent is really that this is the agreement that got breached. And Morgan, I apologize, I skipped over your question from the last section.
Yeah, no problem. I was just wanted to point out something. Sewers are a big thing that you really got to check on. We had a listing that was every house on the street was on sewer. Prior listings for this house was on sewer. The seller told me it was on sewer. It's on septic, and it was failed.
So the comment was you have to be careful. Every other house on the street was on sewer. Seller told the agent it was on sewer. Turned out it was on septic. That causes a lot of problems between the buyer and the seller, and they don't typically find that out until towards the end. And then whose fault is it? It's yours, of course, right? Everybody blames you. All right. The other thing is they talked about risk of damage in paragraph 3, and all GAR did was change. It used to say, basically it says that the seller warrants at closing the property is in the same condition it was. It used to say binding agreement date. Now it says offer date, because that's typically, sometimes they're closed.
Of course it should say that, right?
That's when the buyer has seen the property, right? So that's just a common sense kind of thing. The next thing talks about entire agreement and modification and assignment. One thing I want to point out that isn't a new change in there, you guys, your GAR purchase and sale agreements and your RE forms, but we'll stick to GAR, are not assignable. For those of you guys working with investors that go under contract with the seller and then want to find another buyer to assign it to, these contracts are not assignable in and of themselves. You must have seller written permission, and that's where it has it in there. There is a separate exhibit that is a seller's permission to assign the purchase and sale, but that's not new. I just wanted to point that out to you because we're having some issues with that. Basically, it says this agreement may not be amended or waived except upon the written agreement of buyer and seller. Any agreement to terminate this agreement or any other subsequent agreement of the parties relating to the property must be in writing and signed by the parties.
Well, and to expand on that, to talk about what a writing is, because I get this question all the time, and incorporating anything that goes on, well, I texted him that, or I emailed him that. I can write non-GAR contracts that I can write in provisions that say emails are deemed to be incorporated herein, or I can write anything I want in a non-GAR contract, but we are stipulating here that writings are writings on GAR forms. So that's part of what a writing is in the world of GAR. Emails and such are not considered, you can go to court and you can argue anything you want, but for the purposes of GAR, a writing is on a GAR form. So that's part of what they're talking about there.
And GAR has a whole library of forms for a lot of different purposes. There are termination, because the other part of that too for GAR is it must have whose signature? Whose signature? Buyer or seller, right? Y'all's signature, you can't bind a party to terms just like they can't bind you to terms. So in GAR, it's specifically provided that you need the buyer and seller signature. So a text doesn't have anybody's signature. But So GAR has Form F-519, which is a mutual agreement to terminate a purchase and sale. And in this one, it has a place for both buyer and seller to sign the termination and the agreement to disperse trust funds. It also has a place to divvy out any money that a buyer or a seller would want to pay a broker to avoid a lawsuit. In essence, this is an out-of-court settlement agreement. And the one that people are more familiar with is the unilateral notice to terminate and purchase and the agreement of the proposed disbursement. How many signatures when you see the word notice, how many signatures are required? One. When you see agreement, how many signatures are required? Two. You only need one party signature to terminate. Once it's terminated, it's dead. You need both party signatures to agree to the disbursement of earnest money. That's not only a contract issue, that is a license law issue. That the broker holding the earnest money may only disperse the earnest money. One of the ways is upon written agreement of the parties that have an interest in the money on a document separate from the document that directed them to hold the trust funds to begin with. So, and then there's other things that happen if you don't have that. But anyway, just wanted to point out these two forms that comply with the termination of a contract in writing and signed by the parties. All right, turn the page. Paragraph C4K is a brand new paragraph, Statute of Limitations. All claims of any nature whatsoever against brokers and or their affiliated licensees, whether asserted in litigation or arbitration and sounding in breach of contract and or tort, must be brought within 2 years from the date any claim or cause of action arises. Such actions shall thereafter be time barred.
That is a creation of contract. Actual statutes of limitation for various different things actually have different time periods, but in an effort to streamline and standardize and move things along, they've created this 2-year statute for this contract, which is good. I actually still think that's too long, but you know, I think that what has been built in there is in an effort to give people time to sort of maturate on things, negotiate, work things out, and so that 2-year period has been created for this contract essentially. Any questions about that?
All right. The next one. Binding agreement date. I don't know why. I don't know why.
You don't know why this change was made?
I don't know why there's so much questions about when the actual binding agreement date is. But GAR's trying to even make it more explicit. So binding agreement date shall be the date when a party to this transaction who has accepted an offer or counteroffer to buy or sell real property delivers notice of that acceptance to the party who made the offer or counteroffer in accordance with the notices section of this agreement. Once that occurs, this agreement shall be deemed a binding agreement. The binding agreement date is important. Why? That is the 0 day for all the other time frames in the contract, except a backup contract, which we'll talk about that when we get to that form. But it is day 0 for terms of count, for purposes of counting. Binding agreement date is day 0. It's not day 1, it's day 0. Easy way to think about that, it's fair. Some people will get a contract binding at 8 o'clock in the morning, others at 9 o'clock at night. So that day doesn't count because you could miss out on a day. Question?
Well, it's the same sort of question. And let's say I send notice at 11:59 at night. It is that day still.
No.
Oh, okay.
It depends.
Yeah.
So in the notices section, and this is not a change, the notices section in the GAR contract, one of the things it says is notice is achieved when it's done in writing, by courier, by in person, or electronically. And it defines electronically as email and or fax. For electronic delivery, GAR in the notices section defines receipt when the sender can prove he or she sent it. not when the receiver opens it. And this definition has been changed throughout the past few years with GAR, but this has been the definition for a couple years. So if your email shows that you sent it at 11:59 p.m., then that would be the binding agreement. That would be the binding agreement date. If, however, you don't hit send, or you hit send but it takes a while to send, and it sends at 12:01 or 12, the next day would be the binding agreement. But here's the problem. Here's the practical problem that happens to you guys. And again, y'all are too nice because you're trying to be nice, especially when everybody's all lovey-dovey at first and got under contract, until you're not nice. So let me give you an example. What happens is a couple of things happen. You guys are negotiating at night, right? Y'all are crazy. Go to bed. Go enjoy your family. But anyway, y'all negotiate at night. And a couple of things happen. You'll be going back and forth on a counter offer. And, okay, Bob, I'll represent the buyer, you represent the seller. We're the agents. I write an offer, seller writes a counter offer. I write a counter offer, seller writes a counter offer. I write a counter offer, seller signs it. Are we binding?
No.
No, because we have an accepted contract, but I don't have notice of acceptance. I don't know if I'm going to get a counter offer or an accepted contract, right? So he has a document that has both buyer and seller signatures, but it is not binding upon the parties yet because I don't have notice, okay? Once he sends it back to me, then I have notice. Now the terms are binding upon the parties. Here's the problem. We're doing this back and forth, and now we're at night, okay? And the buyer wrote the last counter offer. I send it to him at night. Bob sends it to his clients, and then Bob goes out to dinner, okay? Bob has a lovely time and is enjoying being with his loved one, and comes back home and doesn't check his work, right? He's like, okay, this is my time. And goes to bed, and I'm blushing myself. I don't even know why I'm blushing. But anyway, wakes up in the morning. I was going to say something else, but I decided that's going to be totally misinterpreted. So anyway, wakes up in the morning, checks his email, and he has received the counter offer that the buyer sent him. He sent it to his sellers. His sellers signed it and sent it back to him last night. Now his sellers, either he did it misunderstanding, but we won't do that on Bob. Bob knows what's going on. But his sellers filled in the acceptance date as last night, February 11th. Bob gets it in the morning because that's when they signed it. Bob sends it to me in the morning today, February 12th. What's the binding agreement date?
February 12th.
Problem is, I'm now the buyer's agent. I'm in receipt of a document that has binding agreement date the 11th. Okay? Not a problem. Until 10 days from now, my buyers terminate. They terminate on the 22nd. Send over the TNR to Bob. Bob's sellers don't sign it to disperse their earnest money. Why? They think my due diligence ended yet on the 21st because that was the date on the contract. That is not the time to figure out when the binding agreement date is because now there's a little bit of contention there. Here's the problem. By the terms of the contract, we have the definition of binding agreement date here, and we have the notices section in the notices section. The binding agreement date of a contract of the GAR contract can be determined without a doubt, beyond all doubt. I don't care what's written on the purchase and sale agreement. As a broker having to write that 10-day letter to disperse earnest money, I'm going to have to go back to Bob and say, okay, Bob, show me the email where you sent the attached document to the buyer. I don't care what date's written on there. It's proven per the definitions in the contract that the binding agreement date was actually the 12th, not the 11th. Problem is, at that point in time, you've got a buyer who's terminated on this contract. You've got sellers thinking they're getting earnest money for being off the market for so many days. You've got a buyer that wants to buy this next house. Seller number 2 is going to want what? earnest money. The buyer's like, I've already given you several $1,000s. Now you're telling me I can't use it? It's tied up. If the broker doesn't have agreement by the buyer and the seller on the disbursement of the earnest money, I can't now allocate that earnest money to a new contract. It's not available. It's tied up. It's in earnest money jail until the jailer, being the holder of the earnest money, one of the things that we can do is write the 10-day letter. Well, I had to take a little time to do the research, figure it out, show me the email, blah, 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 blah. So it's going to take you guys a couple days to realize you're not getting the signed release. Then you send it to the holder, you explain what's going on. It takes the holder a day, maybe two, to get the information, write the letter. Then they send the letter. It's 10 days from the date of the notice. Now, we can't disperse on day 10. You have to give 10 full days for an objection. We can't disperse till day 11. Depending on how the broker disperses the funds, it could be tied up electronically. So this buyer has to wait anywhere from 10 to 12 to 14 to 17 days to get their money, but they don't want to miss out on this house. And the buyer's like, I got to put in more money? You told me it was safe. You told me it was protected. You told me that's what due diligence was for. What's going on? What are you doing with my money? Do y'all see the issue? You guys have got to get the binding agreement date squared away it is what it is, but in an understanding perspective between the two agents. Now, here's the other thing that happens between y'all.
Y'all.
I'm from the north. So which party is really supposed to fill in the binding agreement date in this example? No, the party to receive it. He was the last party to sign it. The party that makes the last offer or counter offer is the one that should fill in the binding agreement date. His people signed it, but he should send it back to me. Notice of acceptance is what creates binding. So I'm the one technically should fill it out. If you guys are negotiating during the middle of the day and it's a difference between 11 a.m. and 2 p.m., don't have a cow. It doesn't matter, right? The day is the day. It's the day that's day zero. It doesn't matter. And that becomes another point of argument, potentially, between agents. Don't let that be an argument. It's the day that matters. The issue is if you receive it on one day and it has that date filled in, because the parties need to understand what's going on. So I'm assuming, Andy, that's why they just tried to clarify it, but it sounds like you might have another comment.
No, I think that's
Sufficient.
I think that I could not improve on what you just said.
And again, like Andy said, as a broker, we deal with this confusion on a regular basis, and the problem is it hurts our profession, because it looks like, what are y'all doing with my money? And it hurts you guys as agents. It hurts the relationship when it's just a matter of contract. Well, can't you just apply that earnest money to the next thing? They're going to get it back. They completely terminated within their due diligence. Yes, but license law says, as a broker, I cannot disperse the funds from the contract, from the document that directed me to hold the funds. I need that separate agreement. That's why we need those TNRs, and if it's not signed, it's held up. So.
Yes. Okay, so now I've learned that I've been binding contracts incorrectly, but, so.
And she's been working for a gazillion years.
They were all binding. Okay, so you as the buyer send me back an executed contract. I bind it in e-sign, and I copy the other agent to receive a copy of it, and I check the check mark that it's going to go as a PDF to them once I put the binding on there in e-sign. Is there certificate of authenticity proof
Yes.
of notice?
Yes.
Okay.
The question is like in my example that I was using, I'm saying, show me the email where the PDF was attached. For you guys using e-sign, which is perfectly acceptable, that e-sign certificate, so sometimes that happens immediately. So that e-sign certificate of authenticity would be proof of when notice of acceptance was handed back. Back to my example with Bob. Let's say I had it, now here's another thing. You guys do not put your co-op agents' clients on e-sign. You really need to just put them on e-sign and let them deal with their clients, because the way e-sign works, you guys know you hit tab and it tabs through. Well, the clients are getting documents related to the transaction. They don't necessarily realize if it's coming from their agent or the co-op agent. If you guys do that, you could have another broker's client sign something that they don't necessarily agree to. It's gonna be an issue. So really, you guys should just send it. But let's say I sent it to Bob. Let's say Bob, when he sent the e-sign to his sellers before he goes out on his date, had it set up where once they signed it, he had it coming back to him and to me. Then when they signed it that night, regardless if he's checking his email or not, if I got that signed contract back through the e-sign, then the binding agreement date would have been when? The 11th, yes. So that e-sign certificate of authenticity would be proof of that.
So you don't then have to attach it as a PDF and send it to the agent again. That's
You
what
don't
I'm trying
have
do.
to, but their professionalism and professional courtesy is one thing, but for the purposes of binding agreement date and the notices section of GAR, no, because there's a certificate that they received that documentation. Yes.
Is there a form that basically, I've seen one or two agents in my time that has like a list of dates when you're supposed, do we have to create those? Or
There
a
is
form?
a GAR form, and I don't have the number, that is something of important dates in the contract. That is a great form once you go binding for you to use, and it's a really nice professional touch. Pull out that form, fill out all the dates, send it to your clients, because they are supposed to be a responsible party. Send it to your clients to keep them aware of what the dates are, and send it to your co-op agent. That's a really nice gesture for co-op agents to fill out. But there is a GAR form. I don't recall the number off the top of my head. Question?
You confused me a second when Bob went out to dinner.
Okay.
So he sent it to his client, and who signed it, and then it went back to you and to the other agent.
Right.
But then who funded it?
So
At that point, are you letting the other agent?
even if the binding agreement date is not filled out on the contract, your compliance brokers are going to say you need that date on there. It doesn't matter. And I'm saying this, especially since I'm being recorded, with a grain of salt. My point is, it can be proven based on the definition of what a binding agreement is and the notices section. But usually what I've seen happen is, like, let's say Bob sets it, I send it to him. Bob reviews it, discusses it with his clients. He knows his clients are going to agree. He now sets it up in e-sign where it will go to his clients. And when he signs it, it'll put a date, or when his clients sign it, it'll put a date on there. So you can set it up where, because he knows it's going to be automatic, if they're the last party to sign, I'm also going to receive a copy of it. Again, okay, guys, we're not going to get caught up in the e-sign programming, but the important thing is knowing what a binding agreement date is and what the notices section of GAR states to be able to prove it. Okay. The next section, I'm going to paraphrase. I'm going to let Andy talk about this, because Andy has provided for Maximum One an entire wire fraud, cyber fraud, disclaimer, that in addition to the contracts, because our buyers and sellers aren't always signing GAR contracts, are they not? We have our client sign this, not included as part of the contract. We have every customer and client sign this wire fraud disclaimer. I also encourage you guys to put a wire fraud disclaimer, cyber fraud disclaimer on your signature, and so forth and so on. But I'm going to paraphrase. I'm going to let you talk about this in a minute. Let me just tell you guys what the changes have been made in the contract. They've reworded, they've changed the verbiage a little bit about cyber fraud to try and make it a little more explanatory, I guess, a little bit more plain English to the buyers and sellers, saying, look, there are bad guys out there that are trying to get your money. Be careful, be careful, be careful. Don't trust anybody, don't trust anybody. Verify through a third party, so forth and so on. So they changed the verbiage a little bit, and they teased out, if you turn to page 7 of your handout, this limit of broker's liability. If you guys will remember, in last year's, so they teased that out. That all of this was one big paragraph. And they had, last year, mid-year, they changed, remember they had really funky initial lines 3/4 of the way up this page? And a lot of people missed those initials. It was just odd, it was just weird. So GAR has just teased out that paragraph, reworded the cyber fraud paragraph, put the limits of liability in bold font, and got rid of those initial lines. So that's based, and I do have, you guys do have in your handout, if you want to compare the verbiage of cyber fraud from last year to this year, you have it in there. But I want to let Andy talk a little bit about cyber fraud, because I know this is one of your huge pet peeves and issues you champion in our industry.
Yes, I mean, I guess unwittingly I've become kind of a voice of it. I mean, it's not a great topic, it's not a fun topic, it's a scary topic. I don't think there's probably anybody in this room that's unfamiliar with business email compromise, which is the way the FBI characterizes email wire fraud. Email wire fraud being when an interloper or some sort of fraudster impersonates someone in this room and tries to dupe a seller or a buyer into either sending their funds, or tries to dupe, say, a closing paralegal into sending closing proceeds to another place. And in the context of your contract, it would be trying to have your buyer send their funds to another place. And that can happen immediately, even with the earnest money, now that, you know, we have to even wire that so much. So all of these disclaimers, you cannot over disclaim. Disclaim, 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 talk about it a lot. And these disclaimers are all great. I have handouts. It should be on every single person's email. If you have sort of boilerplate text that you send with your clients, you should have it at the bottom of that. So it's very important to disclose a lot that there are people that would try to impersonate you. I have some handouts that if you still use physical packets with your clients, I have handouts that I've made. These are not exclusive to Maximum One. I give these out to all of the agencies that I do businesses with. I've given seminars at the to different title companies and to different agencies, and we were close to having an FBI, the FBI embedded in my office to do a sting even. It was going to be so cool. I wanted to be like the next Jason Bourne. I wanted to go to Russia. I wanted to do all kind of stuff, but they wouldn't. It's something to do with my physicality. It was not set for that. But this is a very serious issue. I don't want to even make light of it. My concern actually with the language in the contract that limits your liability to $100 concerns me that it actually makes light of the issue. While there is some case law out there that suggests that that if you make it bold and if you put enough disclaimers in, that the limitation of liability has been held up, please don't fall asleep on that. There are plenty of other cases, one of which was in Kansas 2 years ago, that held a real estate agent liable for a third of the recovery.
I thought it was 80% is what I heard.
There could have been another. I mean, I'm not surprised if there was an 80%, but there was hundreds of thousands of dollars the agent was held liable to pay for the loss of the funds. In that particular case, the buyer literally ended up homeless because they sold their home, their seller's proceeds were taken, and it was deemed largely responsible to the agent's irresponsible use of their email, which caused the agent to be impersonated. The funds were stolen, and so the buyer went to their next closing. The funds were stolen en route, and so the buyer literally ended up with no home. They couldn't buy their next home.
So the agent's email got hacked. It wasn't the agent involved. The agent's email got hacked, and the court still held the agent liable.
Now, I don't want, please do not think, you know, I got my Gmail account here, and I know I'm sitting in this internet cafe, and I'm on my phone, and, you know, it's $100. What's $100 if I'm a little lax here. Please, I know no one in this room is probably going through that line of thinking, but please be diligent in using your MaximumOneCommunityRealtors.com email or your Atlanta Communities email, please, if you do enough Googling on the internet, you will find that the case law is suggesting that over time, the failure to use adequate security in your email protocols is going to be deemed professional malpractice in your industry. So, just food for thought.
So as an agent, how do you prevent this? There are a few ways, and I have some issues up here. The biggest thing to do is to communicate with your clients and customers. Do not trust any wire instructions you get by email. So if we're telling our clients that, and that's part of the verbiage in the cyber fraud paragraph, what does that mean you should not do?
Send wire instructions.
Email wire instructions, right? So a lot of closing attorneys, as well as a lot of brokers, for brokers holding earnest money, we will not wire email instructions, and we prohibit our agents from wiring email instructions. So how are you going to get the wire instructions to your clients? Either in hand, or we mail them to them through the U.S. mail. Is mail as instantaneous as email? No. Therefore, point of practice, when you guys are writing your contracts and you know the earnest money needs to be wired, in the section of the purchase and sale agreement where it says buyer to remit funds, stop putting 3 days. You're going to put your buyer in default because you're not going to be able to get them those wire instructions in a safe manner in 3 days to the point where they can wire it back. The other thing to do when you're talking to your buyers and your sellers is point out to them, if you do get email instructions, call not the phone number or the email address that comes on that transmission. Go Google Andy Hartman. Call his office. Say, I just got wire instructions. I just want to confirm, are these true? Confirm and verify through a third-party contact information. The other thing I've already mentioned, put a wire fraud disclaimer on your email. Nobody reads it, but I think that might help a little bit. And then there's another way. There are some brokers that have a separate rider for cyber fraud protection on their E&O insurance for you guys as agents. Now, I know we have it. I don't know if other brokers have it. It's outrageously expensive. But just in general, how everything is electronic, so that is something to definitely have a discussion with your broker about. So like Andy's saying, this is a brand new thing in the GAR contract. It has not been affirmed by a judge, so I don't know.
They do read those email disclaimers and they have saved butts. I have I have buyers and sellers several times a year that say, is this email legit? I just got this weird phone call, because the fraudsters are calling now, and and they'll say, you know what? I didn't do anything with it because I read that thing in your email that said this might happen. So they are reading those things. So please use them. I mean, you'd be surprised. And I'm weak on this issue, and I'm scared. And I still, when I find out that something almost happened and it didn't, it still gets me choked up. We have had, in the 5 years since this has been a problem, we have had one individual lose money in my office. Now, thankfully, when the FBI got involved, I hate it for him, but he made all the mistakes. We didn't make any mistakes. And this guy was so wealthy that he turned around the next day and wired another $300,000 to us and closed the transaction. But he made a lot of egregious errors in this. And he even admitted to the FBI, he's like, yeah, I screwed up bad. I mean, but this is a serious thing when it happens. But people are reading the disclaimers and they're saving themselves. So please use all these disclaimers. Make your emails look obnoxious with it. Use red bolding. Do it.
I had this happen with closing in your office. That the buyer actually caught it. It was an email that looked like it was from your office, and she had the good sense to check it. And it was $100,000 down payment.
Mm-hmm.
Yeah. I about
And-
died when she called me and said, I said, don't send it. Don't send
Right.
it.
The issue is we always think about this more in terms of a buyer sending earnest money down payment. You guys, it's happening to sellers too. Our industry, from the agent level, the lender level, and the closing attorney level, Andy's emails are getting hacked too for the closing attorney sending a seller's proceeds out. So you guys, you've got to be careful. And the bad guys are getting very, very smart. We also had an agent here last year, 2 years ago, I think, either last year or I think it might be 2 years ago, got a text message on their phone with wire instructions. Guess what phone number that text message was affiliated with? They spoofed or ghosted, or I don't know what the term is. Andy's Professional, do you know that?
See, I don't want you to get the impression that it's always hacking, because we have ironclad computers. What they do is they're hacking someone else. They're not hacking me. They're hacking someone that's got a Gmail account, and then they'll take and they'll spell Hartman Law with 2 T's or 2 N's or something. Then they'll slightly modify. I have bought 14 or 15 different iterations of my email. We buy all the different URLs we can, all the different ways you can misspell an email to make it look close for literally every different person in the firm, so that anytime somebody thinks that they can misspell an email, well, they can't use that one because I own it. And you guys can consider doing the same.
That's a good idea.
Because all you can do is stay ahead of them. And but now that they try to do that with text, and you just have to stay ahead of folks. So what they do is they will hack someone else that has an easy email to hack, like a Gmail, and then once they learn about the transaction, they'll try to create an email account that says, they might even say andyhartmanlaw.com or andyhartmanlaw@gmail.com, which to an uneducated person looks like a real email. And as a matter of fact, the easiest way to do that is with a phone. Here's why. You see this little bubble on your phone? Well, you might look at that bubble and and she'll say, oh, that's just Harry. Harry's sending me an email. Well, if you want to see if it's really Harry or not, click on the bubble and see who the email's really from. Because you can make that darn bubble say anything you want. I can make that bubble say Andrew Ribley, and it's really me. You know? I learned how to do that just by looking on Google. It's easy. So if I can do it, a fraudster can do it.
And it's I'm sure there's other industries, but our industry is fraught for it. And what happens is, you guys have branded email. Dana sells homes at gmail.com is what we like to call a clue, right? So like Andy's saying, they're tracking my emails, and throughout the course of email, you are emailing, here's the closing attorney, here's his contact information, here's the lender, here's his contact information, here's the other agent, blah, 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 blah. So, and I appreciate you bringing up that point. It's not necessarily Andy's email that's getting hacked or your email that's getting hacked, but they're seeing all the other contacts. So then they go and look up everybody else, and they're hacking another one, but they have all the contact information through there. So really a huge issue. All right, that's really it for the purchase and sale agreement. What do y'all think? Not bad, right? Now they've made, GAR's made all those corresponding changes in the various purchase and sale agreements. The lease listing, the commercial purchase and sale, so forth and so on. Do y'all want to cover the financing contingencies and then take a break, or take a break now? Who wants to take a break now? Who wants to keep going? Okay. Let's cover the financing contingency forms, and then we'll take a break. All right? Is that okay with you, Amy? All right. Now, you listing agents are gonna love this next one. Turn to the conventional loan contingency exhibit, paragraph 3. A loan denial letter. So you guys know how financing contingencies work, right? It's protection for a buyer's earnest money if they can't talk a lender into lending them money. This form is for protection of a buyer to get their earnest money back if they can't talk a lender into taking the risk on them, as long as the buyer terminates within the time frame and sends proof of termination, which is a loan denial letter, right? So conceptually, we understand what it is. Now, this form has a lot going on it, but basically, you fill in the terms that must be terminated under, if the buyer's gonna terminate protected earnest money. You itemize or you list a specific mortgage lender. Now, you don't have to, but if you do, if the buyer and the seller agree on an approved mortgage lender, what that means is if a buyer terminates under the financing contingency, the loan denial letter must come from that lender identified. So you listing agents, you probably want an identified mortgage lender. You buyer's agents, you want to leave that blank so your buyer can get a loan denial letter from it. Well, y'all don't want loan denials, y'all want these deals to go through. But what I'm saying is it's more protective of a buyer shopping if you don't have, because then the loan denial letter can be from anyone, right? You can put more than one name, so forth and so on. But here's the thing. This has, the first part of paragraph 3 has always been in there. Buyer may apply for a different loan, right? This is really for terms of protecting a buyer's earnest money if they get denied. But a buyer can apply for a different loan. A loan denial letter, is that terms defined below, must be for the loan described above. Buyer may also apply for different conventional loans and then the loan described above. However, the denial of such other loan may not be the basis to terminate this agreement. That's always been in there. But that's where GAR stopped. Okay, listing agents, y'all ready? This is a wonderful thing. Buyer shall not have the right for an FHA, VA, or USDA loan unless the parties agree to amend this agreement to add FHA, VA, or USDA loan contingency exhibit meeting those requirements as the case may be, in which this conventional loan contingency shall no longer be part of this agreement. Nothing herein, however, shall require the seller to accept it. Why is that a wonderful thing for you listing agents, for your sellers? Let me rephrase this. What happens if your buyer's getting a conventional loan and that's what the seller agrees to, then all of a sudden the buyer changes to an FHA loan? What is the impact on a seller?
Well, I think it's more important too in multiple offer situations if you're the listing agent, because if someone brings you a VA contingency compared to conventional, you want that conventional rather than VA or FHA, but if then they go and change
And
their
switch
loan,
it.
yes.
Because here's what happens too. We've got buyers that are, and so this is a roundabout way of getting back to my question. We have buyers that will, in a multiple offer situation, they know they can get the money. So it's not really a question of that they're going to terminate under the finance contingency. But they want to make their buyer's offer more attractive to a seller, so they go in conventional. But because that paragraph had always been in there, the buyer ends up, it's better financially for their situation with down payment or terms or whatever to get an FHA or VA or USDA loan. Again, what's the impact to a seller if a buyer switches from a conventional to an FHA or VA?
Appraisal period.
Right, there are costs incurred to a seller on a government insured loan that they have to pay. And sometimes, okay, that's not really a big deal because if the seller had been making a contribution to closing costs, whatever. But there's another thing. What'd you say, Morgan?
Well, the appraisal period goes right up to the day of closing.
Number one, on an FHA insured loan, the buyer's appraisal termination rights, if it doesn't appraise, go through day of closing. But what happens if the property appraises less than sale price? Well, regardless of termination, what's the impact to the seller? Another impact to the seller.
Buyer contributes to the shortfall.
No? The buyer can contribute to the shortfall. The appraisal sticks with the property. You now have a lower price on an FHA or VA or whatever appraisal that stays with the property for a specific period of time. Seller didn't bargain for that, right? There was nothing prior to this verbiage. Now, a lot of agents were handling this professionally with the issues anyway, but there was nothing in the conventional loan contingency preventing that from occurring. Listing agents, you like it? Yeah. All right. The other thing is they took out, for whatever reason, last year they put in that a lender could require repairs on a conventional loan, right? We're used to that on an FHA or VA loan, right? They put that same verbiage in the conventional loan contingency, which was very odd, and all of a sudden, we had a lot of lenders, with buyers on conventional loans mandating repairs. And one of the theories is that the lenders were seeing it in the contracts, like, ooh, let me go look, check it out for repairs. They took that verbiage out, and they just made it a special stipulation in case you want to use it. So that's all the changes they made on the conventional, but I think that's a really good change for sellers on the conventional. All right, FHA. Turn to page 15. Now this verbiage that they have added on the FHA contingency, I think GAR just accidentally left it out last year, because we've always had where a buyer and a seller negotiate for repairs on an FHA or VA loan, right? Last year, in the conventional contingency exhibit and the VA loan contingency exhibit, they added this additional verbiage. I think it may have just been a mistake, or it could have been an FHA thing, I don't know, but they've now added it to the FHA loan contingency. Basically, because you guys, for whatever reason, we see a lot of contracts, it doesn't matter the sale price, we see a lot of contracts with $500 for repairs. Well, hello. So typically what we see is the seller shall pay for the repairs and have them completed as long as the repairs aren't more than $500. Like I said, we see this on a $100,000 contract and a $300,000. It's just weird. So what happens if you get an appraisal and the appraiser mandated repairs are more than that amount? What happens? Well, there's verbiage now, and it says, any repairs shall be completed. That's been the same. Now it says, and I'm on page 15 in your actual contract handout, it says, in the event the anticipated costs exceed the amount listed above, the seller shall provide the buyer with an itemized written statement of total cost of the repairs required in the FHA commitment from a third-party contractor selected by the seller. So who now first has to do something? The seller. The seller must go find a contractor and get an itemized list of how much it's going to cost for those repairs. Then the seller or buyer shall have the option to agree to pay the excess amount upon notice to the other party, which shall constitute an amendment to this agreement. If neither party provides such notice to the other within 3 days of the date the seller provides the buyer with the written estimate of the above referenced cost. So it's kind of hidden in there. So in the course of practicality, if the repairs are more than, like I said, let's say we put $500 in them, the seller first must act and must go find a contractor to get an estimate of how much that is. Then it's kind of hidden in that sentence I just read. The seller must then send notice of how much of what those costs are to the buyer. Then it says then the buyer and seller have to decide who is going to pay that excess within 3 days from the date the seller sends that notice to the buyer of the written estimate. If neither party, if buyer and seller don't agree who's going to pay, let's say the repairs come in at $1,500, they'd agreed to $500, there's a $1,000 difference. If neither buyer nor seller agree to pay that additional $1,000, then the contract automatically terminates. This verbiage is also now in that special stipulation that you can use for conventional. It's in the VA loan contingency, and now they have added it to FHA.
You know, that last line though, this is just a technical point. Has anybody, it's been too early in the year, has anybody closed on this yet? If buyer agrees to pay the excess amount, the same shall be paid by buyer to seller at closing. I'm just morbidly curious to see how that's going to play out on the closing statement.
Yeah, because they should pay, because the repairs have to be completed prior to closing. Unless it's a 201k, right?
Yeah, how from a practical standpoint, with the lender involved, is the buyer going to get that money to the seller? I mean, because
How are you gonna enforce it? Yeah.
Well, you're not going to be able to close if the repairs aren't done, because the appraiser has to go back out and do a recheck.
So
Yeah.
the seller's paying the contractor up front and then being reimbursed.
That's sort of how it sounds.
By the buyer, but I thought on the FHA loan, the buyer couldn't pay any funds to.
Yeah, there's certain concessions that can or cannot be paid. You're gonna have lenders that are gonna not allow something to go across the settlement statement like that. I'm just like, let's hold my beer. I mean, let's. I just can't wait to see
Yeah.
how.
Stay tuned for mid-year review,
Yeah.
right?
Yeah.
Because I'm sure this will
Yeah.
come up in practicality.
Yes.
All right, VA. The VA, poor VA loan contingency exhibit. Turn to page 19, paragraph 14. This is the only thing they've changed. This paragraph has been changed. This is the third change in a year to this paragraph. And what happened is, now everybody look up here. In January of last year, this paragraph was titled Certain Fees Paid by Seller. And it stated, notwithstanding any provision to the contrary contained in this agreement or any exhibit attached hereto, seller shall pay all of the following to the same that they are charged as part of the transaction. Then look at this whole laundry list. Termite letter, loan closing or settlement fees, doc prep fees, preparing loan papers or conveyance fees, attorney services other than for title, photographs, interest rate lock, postage,
That's not right.
mailing charge, stationery. Really? The seller has to pay for stationery. Hello. Telephone calls. I didn't know anybody charges for long distance calls anymore. Y'all remember when you used to call and you would call home and say collect from and you had a code so your parents knew not to accept but they knew you got there safely, right? That's the last time I've known they charged for phone calls. Just saying. Overhead, amortization, passbooks, membership or entrance fees, blah, 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 blah. And then, in case they forgot anything, or any other fees, costs, or charges, which are not permitted, right? So inadvertently, what GAR did January of 2019 is they put sellers in a really awkward position, and what they did is they harmed our amazing veterans. Who do I have in here that's a veteran? Thank you guys all and gals, and thank every veteran so much for your willingness to serve, your willingness to sacrifice, your willingness to put yourselves on the line in harm's way to keep us free and safe and independent. Thank you so much. What happened though is GAR put sellers in a position saying, I love you, but I'm not signing a blank check to your lender for what these unknown costs are. And what happened was a lot of sellers were very hesitant to accept a contract with a VA loan with this verbiage on there, okay? It just, that's what inadvertently happened. So, in June of last year, they changed it. They recognized this and changed it. So in June of last year, they changed the title of that paragraph to VA Rules and Regulations Termite Letter. The Veterans Administration has certain rules and regulations limiting the items for which the buyer can be charged relating to closing of the VA loan. Buyer should consult with buyer's mortgage lender to determine how the buyer might be affected. Notwithstanding any other seller contribution, the seller shall provide buyer at or before closing at the seller's cost with an official Georgia wood infestation inspection report meeting the requirements of Georgia law. Termite inspection for the basis shall be done within 90 days. So all of a sudden our sellers were much more willing to accept a contract with the buyer getting a VA loan, okay? That was the change of June of last year. But then they thought about it a little more, and so for January of this year, they've changed it. So now we're on the brand new form. Because all I said before was a Georgia termite letter, right? What do we as professionals in this industry interpret that as? A termite clearance letter. But it didn't say that. It just said a termite letter, right? So they've changed the verbiage just a little bit, and it basically says the VA administration, that same first part is the same, and now it says notwithstanding any other seller contribution, meaning on top of any seller contribution, closing costs, so forth and so on, seller shall provide buyer at or before closing seller's costs, official Georgia wood infestation inspection report, meeting the requirements of Georgia law, dated within the 90 days, that's all the same, indicating that the property is free from infestation. So not only do we need a termite letter, that termite letter needs to say there's no infestation from termites, and that's kind of, we think it's silly because we know we needed a clearance letter, but nevertheless, they've just made it clear to the sellers and buyers, it has to be, the letter has to say there's no termites. But what happens, however, if there's previous damage? In the event that, well, first of all, if there is infestation, the seller needs to have it treated, as the case may be, such that they can get a termite clearance letter. But then it says, buyer and seller acknowledge that the property may not meet VA's minimum property requirements if it contains damage from previous infestation of termites or other wood-destroying organisms. If there's damage from previous infestation, seller shall obtain an estimate from a contractor to the repairs of the damage and provide a copy to the buyer. If the parties are unable to reach an agreement within 3 days of sending notice of that estimate as to who's going to pay, then it shall be terminated. So that's another small little wrinkle that GAR has added to the termite letter. So you listing agents, if you get a VA loan, you know you're going to need a termite clearance letter. If there's previous infestation, it might be a requirement from the lender that damage, if there's damage from previous infestation, may be fixed. You listing agents, go ahead and talk to your sellers about getting that repaired anyway, so that the termite clearance letter can address that before it becomes an issue to potentially delay closing or have a deal fall apart 30 or 40 days from now. All right. One other thing is, how many of y'all have sold condo complexes in the past few years? Or not the complex, but a house in the, condo complexes, woohoo! A condo in a complex. So if you have or have not, you may have come up with a situation that sometimes a condo may not be approved for a buyer getting an FHA insured loan. So GAR has created a new special stipulation, and the special stipulation, it's 526. In your handout, the very last page has it written for you. It says, notwithstanding any other provision to the contrary, if it's determined the property is in a real estate development that is not FHA or VA approved, the buyer may terminate this agreement upon notice the seller and receive full refund of earnest money. There is a website where you can go to find this out, and I believe if you go to HUD.gov, somewhere you work through there and it finds it out for you. They can do spot approvals. Best thing to do would be check with your lender early and up front to make sure that the condo is approved for a buyer getting an FHA or VA loan, or it might be that a buyer could switch their loan. But this is something to determine early on. Yes?
How is that determined by the FHA or the VA?
My understanding is basically a condo complex has to pay a lot of money, and there is an enormous amount of paperwork that you have to send in to get your complex approved for an FHA or VA loan. So there are some condo complexes that are just not willing or choosing for whatever reason to not spend the money or take time doing the paperwork.
The reason I asked that, it's been about 4 years since I've done one. I had one in March for Georgia, and it did not meet the, in this case it was the VA requirement. And we asked, what we needed to do. It said, well, not everybody's a member of the homeowners association, so we called the homeowners association, got it up to the 80% members paying their dues in, and finally got the loan approved by everybody. So I don't know if that's the whole.
I'm not a condo, and I'm not an association.
I don't
So
think so.
I do know there is that, but there could be other things. It could be how much, if there's assessments, or how much is in the reserves, or comment or
A
question.
lot of it is based on how many investors own in that particular complex. I forgot the exact amount, but I just had 2 kicked out this about 2 months ago.
So there's a variety of factors involved in a condo complex being approved for an FHA or VA loan. And your lender should have readily available access to that information.
Yeah, I believe there's even websites that categorize who's in and who's out of them.
If they find this out and it's outside due diligence, you're still going to terminate, right?
if you use the special stipulation in your purchase and sale agreement. If you don't use this purchase and sale agreement in your special stip, and you're outside of due diligence, I don't know if this would necessarily fall, it would, I believe it would fall under, either the financing contingency or the appraisal contingency, probably the appraisal, because the financing contingency is the person a good risk for the money. The appraisal contingency, an easier way to think about it, is the property a risk for the money if I have to get it back and resell it. So it might, I'd have to look a little bit more closely into that as a broker, but it might fall under the appraisal contingency. But instead of there being any delays and so forth and so on, that's why GAR has created this special. So if you have a buyer using a condo, buying a condo, just go ahead and put this in the STIPs anyway to protect that buyer. Let's take a break. How about that? All right.